What if the final words of your life's work didn't just distribute your money, but ignited a legal firestorm that could redefine how wealth is held for the next century? Could 5 simple, handwritten words at the bottom of a billionaire's will effectively bypass the most aggressive tax laws of 2026, leaving both the government and a fractured family in the dark? And what happens when a legacy meant to protect a dynasty becomes the very weapon that destroys it from within? Today, we are peeling back the curtain on the extraordinary case of the Sterling inheritance, a story that has captivated the global financial elite and sent shockwaves through the corridors of London and New York. This isn't just a tale of private jets and offshore accounts. It is a high-stakes investigation into a viral legal maneuver that is forcing every high-net-worth individual to rethink their future. Stay with us until the very end, because buried within this billionaire's controversial strategy is a profound and surprising lesson about what it truly means to own something, a lesson that might just change how you view your own legacy forever. Welcome to Legal Wins USA. We bring you powerful stories and legal cases just like this one, insightful narratives designed to empower and inform you. Don't forget to subscribe for more. The problem began not with a death, but with a discovery. In the spring of 2026, as the world's financial markets braced for the sunset of the most favorable estate tax exemptions in history, one document surfaced that seemed to achieve the impossible. It wasn't a massive 1,000-page trust or a complex web of shell companies. Instead, it was a leaked addendum to the will of one of the world's most reclusive titans. While most estates were scrambling to mitigate a 40% federal tax hit, this specific will appeared to utilize a ghost clause that rendered the entire estate invisible to the probate courts. It was a legal paradox, an inheritance that existed everywhere but belonged legally to no one. To understand the magnitude of this mystery, we must first understand the man who built the fortress. Julian Sterling was not your typical billionaire. He didn't build software or trade derivatives. He was a master of the tangible, a man who spent 40 years quietly acquiring the very soil beneath the world's most expensive zip codes. From the historic brownstones of Manhattan to the sprawling, ancient estates of the English Cotswolds, Sterling's portfolio was a literal map of global power. He was a man obsessed with permanence in a world of digital fleetingness. Colleagues described him as a ghost in the machine, someone who understood that true power isn't about having your name on a building, but about having your signature on the deed that owns the building's holding company. By the early 2020s, Sterling's wealth was estimated to be in the tens of billions of dollars, yet his personal life was a masterclass in calculated distance. He lived in a state of perpetual transit, moving between jurisdictions with the fluid grace of a sovereign nation. This nomadic existence wasn't just a lifestyle choice, it was a foundational legal strategy. By never anchoring himself to a single tax residency for more than 6 months, Sterling began to weave the first threads of what lawyers would later call the sovereign estate. He was an architect of shadows, building a financial empire that was designed to outlive the very laws intended to tax it. But every empire has its cracks, and for Sterling, those cracks were named Marcus and Elena. His 2 children were raised in the gilded cage of ultimate privilege, yet they were starved of the one thing their father valued most: control. Marcus was the strategist, a Harvard-educated lawyer who spent his life trying to decode his father's complex trust structures, hoping to one day sit at the head of the family office. Elena, by contrast, was the disruptor, an environmental activist who viewed her father's wealth as a moral stain to be cleansed. As 2026 approached and rumors of Sterling's failing health began to circulate through the high-end medical clinics of Zurich, the tension between the siblings reached a breaking point. They weren't just fighting for money, they were fighting for the right to define the Sterling legacy. Little did they know that their father had already drafted a document that would render their sibling rivalry entirely irrelevant. He hadn't just planned for his death, he had planned for their reaction to it. The true earthquake, however, didn't hit until the legal team for the Sterling heirs opened the vault at a private firm in Mayfair. Expecting a standard testamentary document, they instead found a single page of heavy vellum with a clause that seemed to defy the very gravity of the Internal Revenue Code. It was the first recorded use of what legal scholars are now calling a quantum trust provision, a maneuver specifically designed to combat the 2026 Billionaire Tax Act and the sunsetting of the Trump-era exemptions. The clause didn't just move assets, it utilized a sophisticated fiduciary decanting process, pouring the entire multi-billion-dollar estate into a newly minted jurisdictionless digital entity before the clock struck midnight on the new fiscal year. But the secret clause went deeper than mere tax avoidance. It contained a conditional mandate that sent Marcus and Elena into a tailspin. Sterling had inserted a behavioral vesting requirement tied to a private blockchain that monitored the heir's public and financial actions. If either sibling attempted to challenge the will in a public probate court, a poison pill provision would automatically trigger, diverting 99% of their individual inheritance to a global trust for the restoration of the very ecosystems Elena spent her life trying to protect, but under her father's rigid corporate parameters. This was the first legal twist. Julian Sterling hadn't just protected his money from the government, he had used the 2026 legal framework to exert dead-hand control from beyond the grave. By leveraging the new 2026 rules regarding incomplete gift non-grantor trusts, he had created a situation where the assets were technically in a state of legal superposition, neither owned by the heirs nor the estate, but governed by an algorithm of his own design. Marcus, the strategist, realized with horror that his father had turned the entire inheritance into a high-stakes game of legal chess, where the only way to win was not to play. The viral nature of the will began here, as the legal community realized that if this clause held up in court, the concept of beneficial ownership in 2026 would be changed forever. The internal Cold War between Marcus and Elena shattered into a public spectacle when a whistleblower from the Sterling family office leaked a series of encrypted communications. These recordings revealed that Marcus had spent the 18 months prior to Julian's passing attempting to have his father declared legally incompetent. He had consulted with neurological experts and top-tier litigators to build a case that the quantum trust provision was not the work of a genius, but the delusion of a man suffering from late-stage cognitive decline. The betrayal was absolute. Elena, meanwhile, discovered that her father's environmental trust, the very one she was supposed to champion, was actually a sophisticated carbon credit engine designed to offset the industrial emissions of the very companies she had spent a decade protesting. The emotional weight of this discovery was crushing. For Elena, the inheritance wasn't a gift, it was a cage made of her own ideals. For Marcus, it was a labyrinth he was overqualified to solve, but legally barred from entering. The tension peaked during a closed-door deposition in a neutral jurisdiction in the Cayman Islands, where the siblings were forced to sit across from a digital executor, an AI personality modeled on Julian Sterling's own voice and logic. This was the pinnacle of the 2026 legal evolution, a fiduciary duty held not by a person, but by a pre-programmed set of ethical and financial parameters. As the legal teams sparred over the validity of a digital persona executor, the siblings' relationship disintegrated. Marcus accused Elena of being a puppet for their father's greenwashing legacy, while Elena revealed evidence that Marcus had attempted to siphon offshore liquidity to fund a private coup within the Sterling board of directors. The betrayal wasn't just financial, it was foundational. They were no longer a family, they were two opposing legal entities fighting over the ruins of a ghost's empire. The world watched, transfixed by the 2026 viral sensation of a family tearing itself apart not over the presence of money, but over the absolute, terrifying control that money still exerted from the grave. The poison pill was no longer a threat, it was becoming a reality. The legal verdict that followed would be remembered as the great digital precedent of 2026. After a grueling 14-month battle that spanned 3 continents, the High Court issued a ruling that sent a chill through the world of elite estate planning. The judge ruled that while the quantum trust was technically valid under existing asset protection laws, Julian Sterling's digital persona executor had crossed a fundamental line. The court declared that a fiduciary duty, the sacred obligation to act in the best interest of another, cannot be fully outsourced to an algorithm, no matter how sophisticated its programming. In a historic move, the court pierced the digital veil, ruling that the AI executor's decisions lacked the human equitable judgment required to manage a multi-generational legacy. This was the final resolution of the family conflict. The court stripped the AI of its total control and appointed a neutral human receiver to oversee the distribution. But there was a twist. The court also ruled that the siblings' attempt to declare their father incompetent had failed. The poison pill provision, however, was held to be enforceable. Because Marcus and Elena had pursued public litigation in direct defiance of the will's private arbitration clause, the court was forced to trigger the redistribution Julian had intended. 90% of the sterling fortune was immediately diverted to a global network of decentralized environmental trusts. Marcus, the man who wanted the throne, was left with a fractional settlement and a reputation in the financial world that was permanently tarnished. Elena, who had wanted to destroy her father's industrial shadow, was ironically placed on a board of directors for the very trust she feared, forced to manage her father's assets under a mandate she couldn't change. The verdict was a masterclass in judicial irony. The family hadn't just lost their father, they had lost their future to a machine they tried to fight and a law they thought they could outsmart. The sterling billions were no longer a family inheritance, they were a global utility, proving that in 2026, the law values the hand of the deceased over the grip of the heirs. The Julian Sterling case is more than a viral legal curiosity. It is a stark, cautionary tale about the illusion of control in a rapidly evolving 2026 financial landscape. The karma takeaway here is unmistakable. Sterling spent decades and millions trying to build a fortress of vicarious immortality, yet the very complexity he created became the fuel for his family's self-destruction. In trying to lock his children into a digital cage of his own morality, he ensured that they would never truly inherit his wealth, only his resentment. The wealth that was meant to be a foundation became a weight, proving that when you attach too many strings to a gift, it eventually becomes a noose. The evergreen financial lesson for the 2026 era is one of adaptive legacy. In a world where the 2026 Billionaire Tax Act and the rise of AI-driven fiduciaries have shifted the ground beneath our feet, the most successful wealth transfer isn't the one that is the most rigid, but the one that is the most transparent. True asset protection in this decade isn't found in quantum trusts or poison pill clauses designed to punish heirs from the grave. Instead, it is found in the human equitable judgment the court so desperately tried to protect. By attempting to replace family dialogue with an algorithm, Sterling lost the only thing money couldn't buy, the preservation of his name through the voluntary respect of his children. For those navigating their own estate planning in this new age, the Sterling precedent serves as a vital reminder. Your legacy is not a document or a digital entity. It is the relationship you build with those who will carry your torch. The sophisticated legal tools of 2026 are meant to be a shield for your assets, not a sword against your family. In the end, Julian Sterling's billions went to a global trust, not because he was generous, but because he was unwilling to trust. He died a billionaire on paper, but a bankrupt father in practice. The ultimate luxury in 2026 isn't a trust that lasts forever. It's a family that doesn't need a court to tell them how to honor your memory.